Now, just like to read to you a statement that has been issued by the attorneys at the Attorney General's Department, and saying that all of us should stop the criticism and, you know, latching on what the judge had to say about them and say all sorts of things about them. And I read a statement is by the Association of State Attorneys, Attorney General's Department, and they say the attention of the Attorney General's Department has been drawn to statements and personal insults directed at attorneys by some journalists, media houses, and some members of the public following the acquittal of Alfred Ghc51.2million Woyome by Justice John Ajet Nassam, sitting at the High Court on the 15th of March 2015. These comments include assertions that attorneys are incompetent, lazy, and have colluded with the accused and the court to acquit and discharge Mr. Woyome. Attorneys take serious exception to these unwarranted and uninformed attacks by persons who have little or no knowledge about criminal procedure and the work of attorneys. Attorneys prosecute a wide range of cases on daily basis in the court, and most of these cases are successfully prosecuted. These cases deal with the thousands of Ghanaian citizens who have been robbed, murdered, raped, defrauded, have their property stolen, or suffered a myriad of crimes against their persons and property. Attorneys secure conviction in over 90% of these cases. Attorneys have also successfully prosecuted several high-profile cases over the years. It must be noted, however, that it is impossible, as all lawyers know, for any lawyer or chambers to win all their cases all the time. That's true. This does not happen anywhere in the world. Failure to win a case does not, therefore, make a lawyer incompetent. Neither does it mean that a lawyer is lazy or has colluded with the party on the other side. Attorneys work hard under serious constraints due to gaps in our criminal justice system. Procuring the attendance, that's what it's supposed to be. Procuring the attendance of witnesses in court, for instance, is a major challenge for attorneys. Attorneys over the years have had to financially cater for the cost of the attendance of witnesses from their own meager resources, since no provision has been made. This is such a serious indictment of the state that they have to pick money from their own pockets to pay for witnesses to attend court. And they say this is an example of the length to which attorneys have to go to ensure that cases are prosecuted in court. It is unfortunate that these sacrifices go unreported, but rather insults and scorn are meted out to attorneys when cases are lost. No attorney worth his salt will take a case to court knowing very well that he would lose the case. Attorneys will work diligently to gather the necessary materials and witnesses in order to prosecute their cases successfully. Talk is cheap. For learned friends who should know better to engage in attacks, sometimes personal, against attorneys when cases are lost is most unprofessional. Some of these attacks are fueled by wrong appreciation of the criminal law and process. In many instances, attorneys have won cases against some of these lawyers. We, however, appreciate learned friends who have discussed these issues constructively. Judges, attorneys, and defense counsel are equal partners in the criminal justice system. It is therefore regrettable for one party to incite public sentiments against the other party for whatever reasons. The Attorney General's office has very good, competent attorneys who work their hearts out to serve the nation. We are all at risk if the public lose confidence in attorneys and in the criminal justice system. Attorneys remain undaunted in our efforts to do what we think is right for society. We would appreciate constructive and forward-looking criticism. We, however, detest outright insults and lies against attorneys. We are determined to do our work without fear or favor. We only ask that the resources needed to perform our function are provided. And signed, Association of State Attorneys, Attorney General's Department. What a note to start the show this morning. That's a very long statement. My guests are seated. Abdul Malik Kwekubaku Jr., Editor-in-Chief of the New Crusading Guide newspaper. And I've seen that most of your comments already are asking why I describe him as the chief interceptor of documents. He has no qualms about that description. Also, Dr. Dominic Ayine, he's my MP for Boga, and he is the Deputy Attorney, Boga East, and he's the Deputy Attorney General. Also, Dr. Emmanuel Akwete, I described earlier as the Martin Luther King award-winning guy. He is the executive. He's the executive director of the Institute of Democratic Governance. Of course, we'll not finish this show without you hearing him use a number of these governance jargons. Yeah. And I am extremely privileged, and I feel very excited to have one of the chief occupiers, Ace Kojo Anan Ankoma. He is a private legal practitioner. He teaches the law, and he taught me civil procedure. Good morning. Good morning. Good morning. You teach the law. You don't have to teach it only in the classroom. That's my meaning. Good morning, gentlemen, and welcome to the studios.
Good morning.
Good morning.
Yeah. Now, subsequently, when we get to discuss the Auditor General's report, we'll be joined by Yao Ejay Sefa. He's the Deputy Auditor General and Parliamentary Liaison and Special Duties. That's what he does. Now,
all these documents.
Very, very fortunate we have the judgments, and all of you have had the opportunity to read the judgment. I'd like to start with you, the Deputy Attorney General. We are aware that you have filed a notice of appeal. You're appealing against the judgment. You're very certain that this judgment is wrong. That's the case, isn't it?
Yes, if that were not the case, we would not be filing the appeal. As far as we are concerned, this judgment represents a travesty of justice. It is a prime example of poor judicial reasoning, leading to conclusions that are totally untenable. For us, the attorneys that conducted this case did their best in order to establish, and in our estimation, beyond reasonable doubt, that the charges preferred against the accused, that is Alfred Ghc Woyome, were sustained or sustainable, in the sense that there were two charges. The first one dealt with the offense of defrauding by false pretense, and the second dealt with causing financial loss to the state. Now, you'll remember that on the 20th of April 2014, the judge had to rule on a submission of no case that was made by the defense. In other words, at the close of the case of the prosecution, the defense took the view that we had not established the basic elements of each of these offenses in order for the court to call the defendant, that is the accused person, to open his defense. And they actually filed written submissions that were vehemently opposed to by the Attorney General's Department. On that day, the judge came, and in open court, he said the accused's submission of no case has not been upheld, and that the accused was supposed to open his defense. Now, Larry, you know, and I'm sure my senior is Sankuma here will agree with me, that when a judge calls upon the accused to open his defense, it means that the prosecution has established a prima facie case. In other words, the basic elements of each of the offenses charged have been established by the prosecution. And in law, the burden that now shifts to the defendant is for him to show a reasonable probability that his story is true, thereby casting doubt on the case of the defense. You realize that in the whole of this trial, we led evidence that showed, and in particular, I make particular reference to the evidence of PW2, Osafo Mafo, who was then the Education and Sports Minister. His evidence was very, very clear.
The judge said very little about that.
Well, that is where I call it a travesty of justice, because he selectively used portions of the evidence that served his purpose. In fact, when I listened to when I read the judgment, it reminded me of a notice that was in the office of the rector of Notre Dame when I was in secondary school. The rector was called Bro Robert. And Bro Robert had a sign in his office that said, "My mind is made up, don't confuse me with the facts." So anytime we're taken to him for some infraction of any regulation of the school, and we tried to defend ourselves, he basically pointed to the sign and said, "My mind is made up, don't confuse me with the facts." Indeed, I think that the judge's mind was made up from day one, and he did not want to be confused with the facts. Because it is very clear from the evidence led by Osafo Mafo that the accused person had no contract with the state, that there was no contractual basis for the claim that he was making, that he financially, he engaged in financial engineering that led to the availability of funds for the execution of the projects in the CAN 2008, for the CAN 2008, stadium. And so, given the fact that in his petition to the then Attorney General, Honorable Betty Mol Idrisu, he represented that he had engaged in financial engineering for which 1.106 billion Ghana cedi, euros was made available. That it was made available, not that it was transferred to the Republic, that it was made available and was potentially usable by the Republic for purposes of the execution of these projects. And that this money that he financially engineered, he deserved a commission of 2%, representing a little over 22 million euros, which translated into the 51.2 million Ghana cedis that he was paid. Now, our evidence showed that this representation that he made to the Republic through the Attorney General's Department was a false representation. That this false representation was in relation to an existing state of facts. And that as a result of this false representation that he made to the Republic parted with property in the form of money. Now, when it comes to the second charge of causing financial loss to the state, basically, once you prove that he had defrauded the state by false pretenses and the state had parted with money, then you have also established that there was no value for the money that was paid. He did not supply any goods to the state, neither did he supply any services to the state. So there was no value for the money that was paid. In that case, once he has taken the money and has not refunded it, okay, through his own willful act, or even if he did it in complicity with others, then you can say that the offense of willfully causing financial loss to the state has also been established. So the evidence on record shows very clearly that as at the 20th of April 2014, when Alfred Woyome was asked to, open his defense, the state had basically made a case against him. Now, the question is, did he lead evidence sufficient enough to cast doubt on the evidence that, was led by the state?
Just hold it on there, and let me come to Asa and Kuma. By your reading, or from your reading of the judgment, will you agree with Dominic when he says the judge was selective in how he decided to assess the evidence that was produced before him and the testimonies, that his mind was made up from the onset, that this is a prime example of poor judicial reasoning?
I believe that the learned Deputy Attorney General speaks from a position that I may not be in. I wasn't involved in the trial. I haven't seen the other evidence. All I've read is the judgment. Is the judge selective? He must be selective, because literally tomes of evidence would have been laid before him. His job is then to sit down and sift through that and arrive at a conclusion which will be his judgment. So he is paid to be selective. It's just that it's not supposed to be prejudicially selective. And you're right, he discounted quite some evidence, said some of them were a waste of time,
right.
his words. And in his view, the prosecution witnesses were contradicting themselves. It appears to me that the accused did not call any witnesses. He testified alone. And after, I don't know how many witnesses we had called.
9 of them.
9 of them. And the Honorable Deputy Attorney General. And let me say that he and I go way back, from the days when we used to argue on commercial law, Professor Mills's commercial law. He was a feisty commercial law student, and I was an equally feisty commercial law TA. Yes, so I was his TA in 92, 93, right? So we go way back, and then we worked together in the same firm.
Very interesting.
So we are on good ground. So the judge must be selective, because he obviously can't reproduce or replicate the entire evidence here. He must select what he believes and what he does not believe. He believed one line of it and didn't believe the other line. So that is what probably gives room for an appeal. So 3 more judges will assess the same evidence and conclude whether he arrived at the proper conclusion. Now, but as I read Justice Ajed Nassam's judgment, I see a judicial person crying out. I think he's literally saying, give me more, and you did not. Okay? Look, we are dealing with a series of engagements and transactions which led to us laying the charges. And let me say off the bat that I agree that the charges were properly laid. But laying the proper charges does not lead to the judgment you require unless there's that unbroken evidential link right through every stage of the charge to when you hopefully secure a conviction. And that is where I find the judge saying, I was not given enough. So on appeal, the Court of Appeal is going to ascertain whether the judge was indeed given enough to come out with a conviction. Now, let's go back into a law. I don't know how much time I have in this, because there was the initial engagement of the accused person with the previous government.
Right.
Not directly as a party, but as an alternate director of another entity, but the contracts got cancelled.
Right.
Good. In the course of all of that, he claims that he secured or obtained some billion euro for building of stadia. That euro never came to Ghana. The Supreme Court said, in fact, if there was an agreement, it would have been unconstitutional because there was no parliamentary approval.
Right.
And so, if he made any direct request for financing at the stage of when Yaw Safumafo and others were in power, we don't know. But we know that then comes the change of government. And this gentleman now appears and begins to make claims in his name. So he files a petition, and the judge is right. The then Honorable Attorney General, Madame Betty Mbodi-Drissu, just didn't get up and say, pay the money.
Right.
She sought advice. We can, today, during Monday morning quarterbacking, say that, well, she sought advice from only one section, the technocrats. What about the officers of the previous government who allegedly engaged with him? There does not appear to be any evidence led at least from the judgment, that the Attorney General's office at the time, populated by new people, had any interaction with the previous office holders who had dealt with this transaction. It doesn't appear any of that took place. Indeed, to my shame, if you look at page 9 of the judgment, the judge quotes the counsel for the state explaining why this took place, and this is what he says. Right. And Ghanaians, listen, quote, "My lord, the Attorney General, who was new in office and lacked the institutional history of events that had already taken place, believed the various misrepresentations." Wait a second. We dare go before a court of this land to say that a person we have appointed into a continuum, because it's an office, so there are supposed to be records. And we expected that during the transition period, there would have been handover and handing over notes. And if there was any gap subsequently, there will be the link backs. Says that our Attorney General was new in office and therefore lacked the institutional history. Where is the institutional memory of the organization? And we go before a court and say that that is why she believed the misrepresentations. So the judge says, hold on a minute. I saw that this person wrote to her, that person wrote to her, this other person submitted this to her. So I do not believe this claim that she was hoodwinked because she lacked institutional history. Now you see, in a criminal trial, if with due difference, if you begin to open such channels, remember that the job of the defense attorney is simply to raise doubt. That's all. He's not supposed to mount any defense because you have the duty of proving your case beyond reasonable doubt. And so if you begin to open these holes, of course expect me that I've sworn an oath to exploit these holes. So you are charging my client with an offense, and your claim as to how you paid the money, he didn't hold a gun to your head, you paid the money, is that you lacked institutional history? Is that a defense? Is that a basis on which to launch a charge or to prove any offense? Now, these are some of the things.
I think, Laddie, with all due respect, I will have to intervene here. I think my learned senior is misleading the Ghanaian public on this issue.
On which of
yes, I'm coming.
Yes, on which of the issues? You realize that I'm probably on your side.
No, please,
okay,
please. On this issue, it is true that in the submissions of the learned, principal, chief state attorney, she did mention the fact that Honorable Betty Mold Idrisu was new in the office and lacked institutional memory.
That's right.
That is no defense when and I agree with you on that, that it is no defense to the lapses that the institutional lapses that led to the payment to Woyome.
Okay, so can we correct this?
Yes.
So you are wrong when you say he's misleading the public on that issue. Because when the judge made this note and quoted the prosecution, he said, this is what he had to say in addition. He said, and I'm quoting him, he gave a plethora of evidence to show that you cannot be saying this about Betty Mold Idrisu.
Yes.
He says, I think this submission is not borne out by evidence on record.
Yes.
The head of legal at the finance ministry wrote, just one point, let's clear it, wrote his view justifying the payment. There were other persons who met to deliberate on the petition. The decision, to me, was not wholly taken by the then minister, Honorable Betty Mold Idrisu. Further, counsel submitted that evidence of Suleimana Ahmed was instructive. I do not see such from his evidence. He never disputed the existence and contents of Exhibit 20, which is, he says also that he also never said Honorable Betty Mold Idrisu was advised by him as chief director, but she refused to take. Again, he also never testified that documents on a contrary position of Alfred Woyome were provided to the minister, which she ignored. It is my considered opinion that such criticism of the then minister by the prosecutor is misplaced.
I'm sorry, Dominic.
Let me then make the point.
Okay.
The point that I am making. Okay. I am not saying that this was not said.
So in which way did I
I was
mislead
not
the public?
saying that there was no admission of the institutional lapses. What I am saying is that as far as proof of the offense of defrauding by false pretense is concerned, this is immaterial.
Well,
It is immaterial.
Okay. So in other words,
I'm coming.
you're saying you disagree with
please,
me.
please.
Right.
I disagree with you on
Correct.
that.
So that doesn't mean I'm misleading the public.
Well,
the facts have shown that I'm not.
from a legal
you
technical point of view, you are misleading the public into thinking that this was material in our proof of the offense
I'm not done.
I'm
All right. So
that is not the
okay.
case.
So where you
That is not
disagree,
the case.
make a note.
Yes,
Thank you very much.
well, thank you. Now, of course, Dominic, I will not sit here and say that this was the only ground on which the Republic, including me, lost the case. Okay? There's a lot more. But I say that the judge was crying out and saying, give me more. Now, so there were a series of transactions before your time. You found it fit to bring Yaosaf Mafo and Adjuma Menu to testify, to show there was no contract. The judge says, I don't think that's really very important. You may disagree with him. This gentleman then filed a petition which went through all kinds of bureaucratic and technocratic advice, pieces of advice to the Attorney General. And then a decision was made to pay after several meetings with the gentleman. When the decision was made, the judge says, Dr. Kwabena refused to pay. And the judge said, on that basis, he went to court. He filed an action. We entered appearance and did not show up in court again. Showed no interest in the proceedings until he had obtained a default judgment. Then we sat with him to negotiate down the default judgment and, surprise, surprise, arrived at a compromise judgment and went to file that compromise judgment in court. And so, in effect, and we may get into the technical issues, procedural issues as to whether you can really substitute a judgment. But be that as it may, you then went to court with a consent judgment. And that consent judgment replaced the default judgment. That became the judgment that the gentleman was seeking to enforce. And even then, you still had meetings with him. You then claimed that you discovered, after you entered into the consent judgment, that there was a letter, institutional history again, which was written, which showed that there was no contract. And so you took proper steps to set the judgment aside. You went before the judge who gave the default judgment for stay of execution. The judge granted it in part. He said, pay 1/3, hold on to 2/3. Yet you went and paid the full amount to the accused.
And he said pay 1/3 because the 1/3 was due and owing.
Well, we pay that and then hold on to the 2/3 when the case is resolved. If you're able to set it aside, in fact, he ordered the gentleman to provide guarantees. Yet you went to sit back and paid the full amount. And the judge says that unfortunately, when the prosecution showed up in court, they tried to blame Martin Amidu for the payment. And the judge, once again, writes Martin Amidu's name in gold and says nothing shows that he authorized those payments.
Right.
I wasn't in court. I'm reading a judgment. That's all I have. So he asked a question. Very well. He might have was called to testify. So the judge says, where's the causal link? Let these people come and tell me in which way this accused person defrauded Ghana. So he asked, where's the then Attorney General? She doesn't show up. Where's the Deputy Attorney General? He doesn't show up. Where is Paul Asimenu, who wrote the advice? He doesn't show up. Where is Neko Etete, who signed the court papers and didn't go to defend us in the default proceedings? He doesn't show up. Where is Magnus Rexankwa, who also wrote an opinion that the gentleman was entitled to the money? He doesn't show up. But when he looks at the letters, it doesn't look as if these were people who were being hoodwinked. It appeared they knew what they were doing. So he says, I don't see the causal link. I don't see that you have proven it. And when it comes to the second charge, he concludes by asking the same questions. Where are these people? But let me end with this. And Dominic, I don't envy you. You have a near impossible task. Because not only are your attorneys refusing to conduct cases on behalf of the Republic, as the judge says, your office leaks like a sieve.
What do you mean?
I'll tell you why. Exhibit 32. Now, you and I are experienced in trial.
Yes.
32 means that it is the defendant's exhibit. It's a memo I deem confidential. Thanks, Dominic, for affirming that. Between the Solicitor General of this country, now hold on a sec. The Solicitor General is the leading professional in the Attorney General's department.
Right.
The Attorneys General are actually political heads. But as the head, the Solicitor General rules. The Solicitor General writes a memo to the Attorney General saying that senior state attorneys and chief state attorneys...
And here we are talking about Martin Amidu as the Attorney General.
At the time.
Right.
And so these people are complaining about their unpreparedness to handle the case and the weakness of the case. This confidential memo is tendered in evidence by the accused person. Wait a second, people of Ghana. Dominic, your department leaks worse than a sieve. How does an accused person lay his hands on a confidential memo? So that, Dominic, if I were to write a confidential memo to you right now, I am not sure that your office won't give it to the whole world.
Okay.
No, I'm not done. Last page, please. This is the worst part. The learned Solicitor General then said that, quote, the other issue is whether we would want to put former ministers on the stand who may be embarrassed under cross-examination in view of the circumstances specified above. So that she was expressing a confidential view that let's not call any former ministers. The way this case is, they will be embarrassed. So that probably informs why we didn't call all of these people. We were afraid of embarrassment. So there's a new principle, embarrassment of witness principle, which informs our decision not to call certain witnesses. But you know what is curious? We have called the Osei Mafo and Kwekwadjuma Menu. They were not covered by this new principle of embarrassment.
Oh, please.
But others were covered by it. But this is the worst part of it. This document is tendered in evidence by the accused person. The Honorable Deputy Attorney General, can you explain to the people of Ghana how a confidential memo to the highest officers of the Attorney General's department ended up in the hands of an accused person who we are not told got it through any discovery process or forced production process? Now, if or intercepted by Kokubako.
Well, yeah, I think you should ask how Kokubako intercepts this document.
Now,
then
if this document gets in evidence,
you know,
no, the seriousness is something we can't downplay. I don't think the Honorable Deputy General can downplay. Now, if you give this document to a judge who says that you effectively were stacking cards, you won't call certain people because you are afraid they'll be embarrassed, what judgment do you expect to receive? I'm done.
So, for example, how do you respond to this aspect of Exhibit 32, a confidential memo in which some of the attorneys who were supposed to be handling this case complained that they were not in a position to handle it, more because of the weakness of the case?
First of all, let us distinguish the cases in issue. The case referred to is a civil matter that was pending
at the commercial court. Right.
This is not a reference to the criminal action before Ajit Nassam.
That is right.
Okay, yes.
We wouldn't know, but
take that from me. Take that from me because I have access to that memo.
Very well.
I have that access. Access to that memo. It is in relation to
the civil matter.
The civil matter.
That is right.
Not the criminal matter.
That it came in the criminal matter.
Yes, it was tendered, and I do agree with you that the leakage is unpardonable. That we should not accept a situation where.
Have you investigated it?
Can I finish?
Oh, suddenly you want to finish. You butted into my...
Well, I would say I'm agreeing with you. I'm agreeing with you that the leakage is unpardonable because confidential state, documents should not be leaked to private citizens by maybe our own staff, okay, because of the fact of confidentiality. And all of them as bureaucrats, take the oath, of secrecy. So they are in breach of that oath. Now, the question whether we have investigated it is another matter altogether. I would not state publicly here whether we are doing that. Okay, but let me say that when the judge says that these officials who were intimately involved have not been called, and therefore it weakens our case, I beg to disagree. I beg to disagree because, look, all throughout, we are all in this country, all throughout the trial of the accused person, Honorable Barton Oduro went public with his views that the payment was legitimate. So did Honorable Betty Mold Idrisu, also publicly stating her views. In fact, she was on Star FM the day before the judgment, defending the action of payment to Alfred Ghc51.2million Woyome.
And in fact, these officials were simply repeating to the public what they had done officially in office by writing.
Yes.
Because they had written advice, written to the president,
Yes.
and, you know, justify the payment.
Yeah, that alone is not sufficient to disprove the fact that we were defrauded as a republic.
Okay.
All right. The complicity or otherwise of state officials in this action, okay, whatever they did, their actions and inactions do not go in any way to establish the fact that we were defrauded. Because, you see, when you talk about defrauding by false pretense, the diligence or lack of diligence on the part of the person who consents to part with the property is not an element of the offense.
I agree with you.
It is not an element of the offense. And therefore, if we led evidence to establish that in spite of the fact that Betimol Idrisu wrote approving the payment, in spite of the fact that the advice given by the legal officer of the Ministry of Finance was to the effect that under international best practice, you know, the fees for financial engineering range between 0.5% and 5%,
right, and
that he was recommending a payment of 2%. In spite of that advice, if the state was, acting on false representations, if we prove that it was a false representation and that we parted with property, that was sufficient.
Okay, that is very, very
That was sufficient.
But there's a small...
So the diligence or lack of diligence of these state officials, and I'm coming, I just wanted to underscore one fact.
Okay.
You see, if we had called Betimol Idrisu, Honorable Martin Odru, Paul Asiminu, and so on, I am sure the same people who are crying foul today and saying that they are the star witnesses who ought to have been called would have said to us, we know the public position of these people. We know that they believe that the payment was legitimate. You are just setting up this case to fail.
Okay.
The public would have said that.
Okay. But that's what the judge tells you. You are doing a case, and the judge tells you that I believe that you needed to call these people.
The probative value of our evidence does not depend, on the fact that we did not call, Betimol Idrisu to tender the document that she authored.
All right.
And let me ask one question: Are Ghanaians? Are you guys telling us?
We are Ghanaians. We are Ghanaians. We are not you guys.
Okay, you are okay. Are we being told? I'm sorry about my slang, but are we being told that
by the judge?
Yes, that if Betimol Idrisu died yesterday, or God forbid, but Nodru and the rest of them died, the state's case on the criminality of this act should have been foreclosed forever. That we would not have had other state officials who could, tender in documents to prove our case.
Certainly not. It's just a minute's reaction. Let me get Kweku on here now.
You have state officials who, you're right, have stated their position that they thought we never had a case. But you also have the former Honorable Attorney General who believed that she paid the money under a mistake. And so went to court to try and retrieve it. Yes. And now says that she doesn't think it's a mistake anymore and that we never had a case. So we have a shifting position. Is it that, and Honorable Deputy Attorney General, let me ask. Is it that you people this time, because you are our lawyers, the people's lawyers felt that they probably might have been complicit? Because if you prove that this gentleman has defrauded us, and these people come in to say that in our view, he was entitled to the money, then there is participation in the fraud, which would mean that you have to charge them with the offense.
Okay.
Is that the reason why you're talking about embarrassment?
That's another leg of the discussion that we will come to.
I will state my opinion on that.
Kweku, you've had the benefit of reading, and I see that you even still this morning, you are still making notes. What is your view of the judgment?
Interception.
It's a very sad.
How he does it, he won't tell you that one.
Very, very sad. I'm almost speechless. I'll tell you something. I think that and it's so difficult when some people are your friends and you've had a long-standing respect for them, and yet it gets to a stage you ought to speak and speak frankly. Look, I think the fundamental defect in all this was that they didn't put on trial certain personalities. At least they should have asked them to appear before interrogation panels, investigate them, take their statements, and then charge them. If the courts freed them, fair deal.
Who are you talking about?
Madame Betimol ought to have been one of those who ought to have been prosecuted. I'm telling you, if you look at the trajectory, the history of all these things, what is this thing about institutional history? Along the line, there were signals to her that the thing was not sustainable. Kwame Tete's letter, two letters.
And
from
those
Kwame
letters
Tete.
never went into evidence.
Incredible. Absolutely incredible. Look, this whole thing is making us look like a banana republic. These two letters were written to the Honorable Attorney General of that period and was told that Woyome or Empower Park and all the rest had nothing, absolutely nothing to do with the Waterville contract.
Again, help us. Where was Kwame Tete coming from?
He was then representing Waterville,
okay,
who were also making a claim that, to me, was fraudulent anyway. But indeed, most of the things went back into Woyome's favor. Waterville and Woyome started collaborating when Kwame Tete was taken off.
As Council of Legal.
Yes.
At the Finance Ministry.
Nothing. And how couldn't they see it? People like us, small minds, laymen, could see through. So how did they not see through those things?
It seemed to suggest from the way he reacts to these letters, I get the impression that he feels that these letters would have been the game changer in the whole matter.
Because if these letters have been put in court, the judge will ask, why are these people not on trial?
Thank you. I agree. 100%.
Why are they? The judge would have moved from merely, why didn't you call them as witnesses, to say, why are these people not on trial? Look, we all forget that the state informed us, Iyoko informed us, that one of the principal actors took money. What happened to that case? Nolly prosequi. Now, I'm sure the learned Deputy Attorney General will tell us that, well, they have the absolute discretion to file nolly prosequi, and they don't owe anybody an explanation. I hope that's not what he says. But because my view is that with the coming to force of this Constitution and Article 296, there's nothing like an unfettered discretion. Yeah. So you must be candid with the people of Ghana. Tell us, why did you not charge them? That is the question Ghanaians are asking. It is not insulting attorneys. That's not right. Okay, but we are asking, why didn't you charge them?
This is Woyome's police statement. You recall, we nearly had a problem. In fact, he actually sent us to court for contempt. Some of us, about 10 of us, were lined up in court. David Annan was his lawyer. This is 14th March 2012. A statement to the police, where he tells the police that the political executives at the castle went through all his documentation with him and came to the conclusion that he had a case. He mentions Alex Segbefia, he mentions Valerie Saki, he mentions the former chief of staff. All of them dealt with him. He says the AG, with her eyes wide open, signed onto the so-called agreement. Look, from day one, you see, it's this thing, the way we do our politics in this part of the world.
Thank you.
Transition periods. People play the victim. Look, I was part of this new government or an ally. The previous government did this or that damage to me. I need to be compensated. He plays the victim. He puts up that picture. And both sides, the person making that, painting that picture, and those who are collaborating with him, all have the same political mindset.
Is it either Betty or Bat Nodro? One of them had sort of bought into his petition to suggest that this was the second time his contract with the NPP government was being cancelled.
Yes, it's that mindset. It's a reflection of how the kind of politics we've been doing. So you play that card, you easily win. And under the transition, it was to show that, look, the previous government was vindictive. It was attacking people. So there was no basis even to consult the previous officials. They created that Chinese wall so that they themselves couldn't jump over it. They secured, they thought they were okay.
Okay, so now I'm beginning to hear Ace, I'm beginning to hear you all speak sort of in favor of the state being in a position to win this case against Woyome. So perhaps the appeal is important to pursue.
No, but you see, there's something else. Fortunately, we have two good lawyers here. The case that you were fighting to set aside, I don't know the status. But the Supreme Court's review judgment appears to have
Put
actually,
finality to
yes.
that.
It's a tuse.
Yes.
It's not pending anymore.
Yes.
But you know
Yes.
the
Did the
unfortunate thing
judge,
about
did
that?
the High Court judge?
No,
You know the unfortunate thing about that?
I think she
when the
stayed it.
Supreme Court ordered the refund of the money,
Yes.
the Supreme Court did not order interest.
yes.
Yeah, but the Supreme
And they
Court
went
declared,
back. They went back on a review. Mr. Amidu went back on a review, but the Supreme Court said it cannot review its own review decision.
Yes.
Okay.
So actually, what we have is just the 51 million. In fact, he could have taken the money, invested it, and given
No,
the money back
it's-
to us.
let me read
That's
this.
the end of
Yes.
it.
I want the
But
education
I
on
think
this.
we should ask a very important fundamental question
About the
which
status
is
of the
effect
commercial
of the,
one.
Sup-
Yeah.
the Supreme Court. I mean, judgment. The Supreme Court has made a definitive pronouncement on the legality or otherwise of this so-called
of the
transaction,
transaction, yes.
and has said that there was no legal basis, there was no constitutional basis for this payment.
Right.
Now, one would have thought that in a world where common law principles of judicial precedent operate fairly well, that the judge would have taken note of the Supreme Court's ruling, right, in determining one of the elements of the offense of defrauding by
You're
false
talking about
pretenses.
Ajit
Ajit Nassam should have taken note of what the Supreme Court has said. He is bound by the decision of the Supreme Court on this matter.
Did you persuade him?
The Supreme Court itself said that this decision we are making is without prejudice to the criminal proceedings.
Right. He said that without
he could have taken notice of it.
No,
But he wasn't bound in the strictest sense of judicial.
No. Please. When the court says that.
Just a minute.
No.
Just a minute. Why is it, or you didn't put that also before the court?
No, we
to
did.
edge this on him.
No, why should we? I mean, we don't need to tender a Supreme Court. I mean, this it's a public record and a decision of the highest court of the land. And we did refer to the decision in our submissions.
But you want the guilt of a person in a high court to be
please.
No, you want him to declare. May I finish?
Okay.
Don't let me finish. You want the guilt of a person in a high court to be determined by the civil proceedings that took place in the Supreme Court.
Please. I am not that. I am not that.
We'll deal with this part of the issue.
With all due respect.
We'll deal with this part of the issue. Kweku, finish your point. Kweku was on the floor.
The education I wanted, some partial answers have come in here, a bit conflicting. But this is the review ruling, the judgment. This paragraph, the 2, it says a declaration that the High Court, which purported to and assumed jurisdiction in the court concerned, commenced by the third respondent as the plaintiff on 19th April 2010 in suit so and so against the first defendant.
That's the original suit by Woyome.
Yes, yes. The Supreme Court in the review said, consequently, I've jumped. Consequently, those proceedings and orders consequent upon the said proceedings and orders of the High Court are thereby declared null, void, and without effect whatsoever. Yes, so I am asking that did the High Court judge not have to consider, because when I'm reading the judgment, he made references to the commercial
court, yes.
Yes, the default judgment and all. But I thought
you are saying that he's defrauded you.
Yes.
But from the look of things,
it was
a judgment of the court.
Yeah, but those proceedings and anything that
let Kweku finish his question.
Yeah, I just want education.
Now let me try and provide it.
I thought
He's not finished
those
the question.
proceedings and whatever came out of them had been declared
Invalid
by the Supreme Court.
Unlawful.
Yes.
Okay.
But the law doesn't end there. When we talk about stare decisis, but on what grounds? Remember that first when Martin Amidu went to court, the Supreme Court ruled against Waterville but declined jurisdiction with respect to Woyome.
Yes.
It said because it was a Ghanaian, Article 1815 didn't apply,
yes.
which is that it wasn't a foreign transaction which required parliamentary approval.
Yes.
Martin Amidu went back to the Supreme Court and said, you are wrong.
Yes.
His alleged contract was based on an international contract without parliamentary approval. So if you have removed the foundation of his contract must also fall.
Yes.
The Supreme Court said yes. The Supreme Court did not say that he had tricked government. Supreme Court didn't say he had made misrepresentations. Supreme Court didn't go into all the ingredients of defrauding by false pretenses. All they said is that Waterville had no contract. And to the extent that Mr. Woyome's alleged contract was built on the Waterville contract, if the Supreme Court itself had removed the foundation, that other one falls.
Okay.
And so on that basis, the High Court...
Can I ask you a question? Let me ask you a fundamental question.
So you don't allow me to...
Please,
just note that question. I want to come back to you, so just note that question.
Just 2 sentences. So the grounds that the Supreme Court set, they removed and declared the proceedings void was that the proceedings were without jurisdiction.
Yes. Yes, so it means the judgment, the default judgment, the consent judgment, all those things
were without jurisdiction.
Okay. Yes,
but
so they don't exist.
So they don't exist. You're right. Yeah. But on different grounds.
All right. And interestingly,
so if they do not, exist, if they are considered a legal nullity, how come the judge referred to the commercial court judgment and said that this was a payment of a judgment debt?
The question I also asked is, why did you not urge this on the judge?
We did.
I don't see.
We did urge. No. I mean, in our written submissions, we did. All right. And then also, in fact, when the the accused person tendered the commercial court judgment, during his evidence, okay, we wanted to cross-examine him on it, and the judge disallowed our cross-examination.
Wow, okay.
And the Supreme Court then the review judgment.
Yes,
then
very interesting.
It had come.
Now you had the question.
It had come.
You had the question of me, Dominic, and the question was that look,
you asked him a question. He
wanted to ask. Okay, look, the foundation had been removed. It did not mean that by the judgment of the Supreme Court, an offence had been committed. No, you still have to go and prove the offense, because this is not the first.
But I don't see why the High Court judge then was relying
this
to any extent
this is one of the things that we can depend on. Okay. You see, and that's why I'm happy about the appeal. But the point I'm making is that this is not the first contract that the Supreme Court has set down or has set aside on the basis of the fact that there was no parliamentary approval.
Yes, sure.
In many of them.
Right.
So and it doesn't mean that all of those people defrauded the state by false pretenses.
No.
So it means that there was still a burden on you to prove the offense, notwithstanding what the Supreme Court has said.
And that's what was the effect of the Supreme Court's comment? This comment. It said that in the Martinamidu case, he said that under the circumstances of this case, there was absolutely no sound legal basis for the pursuit of the claim by Waterville and Woyome against the government of Ghana. It should have become very clear to whoever was in charge of directing affairs at the Attorney General's office that the claims of Waterville and Woyome against the government of Ghana cannot hold water.
Yes.
He says they removed whatever Waterville's grounds was, but they declined sort of to bring Woyome in that matter directly.
But subsequently did.
Yes. So I'm saying, how come that all of this was lost in the present matter, which has led to the acquittal?
No, I don't think that it was lost. This is a matter of public record, okay? And we had pressed these issues on the judge. He just simply decided to ignore them. He decided to close his mind to the effect of the Supreme Court ruling on the legality or otherwise of the payment to Woyome. Now, I agree entirely with is that, the Supreme Court judgment is not ipso jure, as a matter of law, proof of the guilt of Woyome.
That's right.
Okay? But it goes to prove that the basis of the representations that he made to the state, okay, were non-existent.
Okay, very interesting points.
They were non-existent.
We're taking a quick break at this point, but before we do that, I want to hear Dr. Emmanuel Akwete. Now, after the judgment, you certainly would have followed the media, how people have expressed their misgivings in such angry mode. Some people are very angry, and you hear them speak to the press, and they feel that, look, what is happening in this country? When you hear all of that, how are you able to, sort of get all of that together within you as a governance person, and how that may have effect on the institutions of state, people's confidence and everything else?
I think if you put aside the lawyer's technicalities and you want to look at it from a governance point of view, within a brief span of about 3 weeks to a month,
right,
the courts have made a decision that seriously raised questions about state bureaucracies. It's an institutional question. How they do their work, in defending the public interest and ensuring that the right things are done.
Will the state
to
attorneys
law.
disagree with the judge on that?
Well, I've heard their statement, and also the opening comments by the Honorable Deputy Attorney General. But I think it doesn't change the broader issues, because there are also issues the Deputy Attorney General has admitted, the things that are internal that they probably would have to look at, and so on and so forth. So that the public's anger, properly studied, still points to how was the interest of the state represented and promoted and projected. And what people wanted to see is that if there was no basis for a payment, the state officials would do everything right within the law to bring whatever the recovery is. That's what they wanted to hear. But they haven't had that. And now there is a case where the person involved has even been acquitted on a criminal charge. So there's a legitimate case about that. But I think when we come back, it's important to also look at the real issues that this is confronting or challenging an effective execution of the rule of law. If what Kweku said, I mean, there were, well, the lawyer Tete's thing that didn't go, the conversations that took place, the politics of MPP, NDC, and so on, and then what it has resulted in. Clearly, we are in a situation where we seriously have to begin to look within. It's not only getting the correct judgment done and the money refunded, but we depend a lot on the state bureaucracies and institutions. And the integrity of the institutions and how they perform their jobs ought not to be a question in public. So there are challenges. Even in their own letter, the attorneys were saying they had constraints. They were not getting the resources to work, and so on. Then you also hear that there is some serious political interference in the process. How come that attorneys would say the minister did not have institutional memory, what you call, the lawyers call institutional history? How come that attorneys who set up a case now, after the previous Attorney General had left office, now are saying we don't want to go ahead? It's a weak case, but they prepared the case, and so on. And it raises a lot of questions about the mechanisms, institutional mechanisms, reviews, oversight, who is responsible for what. A chief director is mentioned, but you do not see the relationship between the chief director of a ministry and the director who has prepared a case for court, or the attorneys, and how he assessed it and said we can go or we couldn't go. It's a whole, well, kind of worms. And I think in that case, if we move away from the personnel, maybe what is considered by the insults and so on, I think some important questions have been raised by the court that needs to be addressed as well.
Thank you very much, Dr. Emmanuel Akwete. We take a break here, and when we return, we're continuing with this issue and also asking the question that most of you want to know. Will the monies be recovered? We'll be right back. It's not suggesting that a prima facie case should mean conviction is guaranteed.
No, that's not what I'm saying.
Now, remember, and as we always say, that the burden is to prove beyond reasonable doubt. And so when you call on me, the defense attorney, to open the defense, all I have to do is to raise doubts. And so it is possible, I don't know. Then I begin to tender documents through my witness. Look at your confidential memo. Look at this letter you brought. Look at all of this. And if you look at the sequencing, a lot of these devastating, compromising letters came from the
prosecution.
No,
the defense.
Defense.
Okay.
Through prosecution witnesses,
Yes.
and a few through his own witness. Now, so that in the judge's view, by the time he finished, he had raised sufficient doubt on which he couldn't secure a conviction. I disagree with on certain parts of it. I agree with certain parts. I'm two minds on whether to go back.
But that's not the basis. You see, he did not even evaluate the evidence of the accused.
Okay, what do you say to that too? When you read the entire judgment, there is very little mention or assessment.
In fact, there is no
assessment of the prosecution's.
I agree completely with you
that
he doesn't go into what the gentleman said at all. And I think on the few that I stumbled on in court, I was okay. Is that all? Right? But he comes down, and Dominic is right. And this is probably one of the things that we need to take up in appeal. That he comes down very hard on evidence that he had claimed established a prima facie case. Then he gets down very hard on it. But you see, this is my point. I think that, say what you may, the main issue for me in reading this judgment, like a gazillion times from yesterday when I got it, is that he was just saying, give me more.
What more did he need? That is
He needed honorable.
No.
I don't think that was what.
Hold on, just hold on.
He listed them.
Page 31. Page 31. This is what he says. In the instance case, what prevented the prosecution calling Honorable Betty Modudrisu? What of Paul Asimenu, Samuel Nekwe Tete, Magnus Resdankwa, the chief operating officer of the local organizing committee, to testify? Honorable Batinodro, the then Deputy Attorney General, will all of them, he says, will have been good and credible witnesses than those that have testified in this case.
He said it twice.
How did he come to that point?
On page 15.
That they would have been good and credible witnesses.
No, listen, he concluded...
There's a question I'll put to you on that.
He concluded every judgment on the 2 counts with the same words.
Yes.
So when he dismissed count 1, he went and said, what prevented the prosecution to call the former Attorney General, who wrote a lot of opinions justifying the payment, to testify? What of Paul Asimenu, head of Legal Ministry of Finance, who also wrote justifying the payment? Mention must be made of Nekwe Tete, the Chief State Attorney, Res Magnus Dankwa, the government consultants, as well as Honorable Batinodro. He says, all of these personalities were not called as witnesses to prove the charges against the accused. But the question will still be whether the onerous burden of proving the charge beyond reasonable doubt had been discharged. Listen to him. For the foregoing, I have no qualms at all in discharging Mr. Ghc51.2million Woyome on count 1. On both counts, he ends his judgment with the fact that, in his view, these critical people didn't appear to him as witnesses. Now, from the documents that Kweku is talking about, Mr. Tete's letters, and Mr. Tete is no mean personality in this country.
Yeah.
The knowledge of law in his head, right, can sink a ship. He writes to us that Ghana, you don't owe these guys a farthing. We pay. When the case goes to court, we do not put those letters before the court. I don't want to put
your brief comments also on where the judge says that most of what the prosecution did, witnesses did, actually went to support the fact that Woyome got the money through genuine means.
Well, we may agree or disagree with him, but here he is evaluating evidence before him. Listen, he has the right to be correct or wrong, and that's why we have appeals. He says, from what I look, all your witnesses literally came in, not only contradicting themselves, but providing more ammunition to the defense.
Right.
And the rest you brought were, in his words, waste of time. He said, you brought something from somebody from public procurement. It was a waste of my time. Ajimamenu, you shouldn't have bothered. Honorable Osei went through the embarrassment and was cross-examined ad hominem. And he said, at the end of the day, he discounted all of it.
No.
And he's entitled to discount it. Because you see, look at what he did to the evidence of Honorable Osei. He just made one little reference to it and said that Honorable Osei was not even happy with the Akosombo meeting. Yes. What in God's name does that mean in practical terms? I agree with you. Right? Well, you will know because I have seen the evidence. I've gone through the evidence in chief of Honorable Osei, and he laid credible evidence to show that the state had no contract with Alfred Ghc51.2million Woyome for which any payment had to be made. That evidence in chief, I'll tell you why the judge should have engaged with that evidence in chief. I'll tell you why he discounted it. He said all of that was irrelevant. Why? Why? Because the agreement on the basis of which Mr. Woyome was paid was entered into with the Honorable Attorney General. No. No, wait. No, you see, you may disagree with him. But let's put the facts. He writes a petition saying that with the previous government I had an agreement, and then the agreement now
But again, shall we move on? But again, do you think that it was a fair evaluation where the defense it's not what he did doesn't feature in the judgment? Oh, I completely agree with you that. So, but maybe in the way of writing his judgment, he didn't do a recount and evaluation or obvious evaluation of the case of to give a balancing act. That's fine. But I'm going beyond that. I'm going beyond that. We all seem to forget that when this gentleman sued in the High Court, the proceedings that Kweku refers to, he doesn't base his claim on the previous thing.
He says, I have an agreement with the current Attorney General that I'll be paid a certain amount of money.
Yes.
It is that agreement that triggered the payment.
Okay.
Whatever the antecedent.
But that agreement has historical antecedents.
Yes. Now, so you go to court and bring the people who were in the historical antecedent on the lack of your lack on your lack of history, and don't bring the current people who dealt with it.
Thank
and
you.
you want him
Thank you.
to,
Can you,
to,
can
to
you
do
now
your work
answer,
for you?
can you now attempt to explain why you did not call these people the judge says were the most important witnesses?
Well, he says if you call them, they will.
We went. I mean, of course, in all this, this trial, okay, was conducted by our attorneys under our supervision. We had several meetings and we had discussions with respect to whether or not these were witnesses that we wanted to call, and our judgment was that, based upon the public statements and the stance that these people have taken, if we were to call them as witnesses, then we will have to treat them as, each one of them, as a hostile witness.
Hostile witness. Cross-examine them.
We would now have to be cross-examining each and every one of the witnesses that we ourselves have brought.
That is what you should have done.
Now, Ace, you very well know, and I'm sure you would agree with me that the probative value of that evidence, okay, from the beginning, would have been very, very low.
Charge them.
Well, that's a different matter altogether from using them as witnesses.
Yeah, good.
Do you get it?
Okay, let's ask
It's a different
Why didn't you charge them
altogether.
Yes.
Why didn't you charge them?
Ace, please hold on.
Now, you asked me one question.
No, I'll move beyond that. You've been asking me questions.
You are not a judge. You are not a judge. You are a senior lawyer.
Why did you charge them?
Let me do that.
You let Samson do the asking. And the question that Samson has asked me, which I am attempting to answer.
The juniors who are asking questions.
Is that, why didn't we call them as witnesses?
You've answered
and we think that they would have made poor witnesses for the case of the state. And that the people that we called, for instance, Honorable Osafo Mafo, had intimate knowledge of the historical antecedents of what Woyome was claiming.
But you want to prove historical antecedent, but not immediate precedent?
Sorry.
No. Yeah, and he came and gave evidence that showed clearly that there was no transactional, a legitimate basis for the payment that he was demanding.
Going forward and measuring the public outcry and anger,
yes,
are you contemplating the possibility of looking at these people in the dock rather than charging them rather than making them witnesses?
Yeah, to be honest with you, we haven't made that decision yet officially. It is not something that we have not considered. And I'm being very cautious with what I'm saying, because no official position has been taken definitely as to whether we'll be charging them.
But you have considered it?
Yes, we have. Yes, we have. But how come
some of them were initially together charged with together with Woyome and were
my boss was not then the attorney general, and I was not then the deputy attorney general.
So there's a lack of institutional history here.
No, it's not about institutional history. It is about a decision that was taken by the then attorney general to enter a nolle prosequi. I agree perfectly with my brother is that under Article 296 now, you cannot say that that discretionary power can be exercised without question.
In fact, okay. I could get up and hug you.
So I agree perfectly with him. But then, if we have to bring them to court, then it means that we will be reversing what the former Attorney General has done.
Why not?
If it is in the public interest for us to reverse it, we have no qualms doing so. But as I've said, we have not taken that, we have not crossed that bridge yet.
Koku, your hand has been up for a long time now.
The name Magnus
Dankwa
is mentioned there. And what role was he supposed to play?
He was the chairman of the
local organizing committee.
It had absolutely nothing to do with the issue that was at stake. Absolutely nothing to do with it.
You disagree with the judge? That this was a material witness?
What was he going to say?
He wrote an opinion.
His was, but it was different.
He was asked.
He was talking of, Woyome had put in a request for reimbursement of some monies that he thought the local organizing committee owed him and a company in Britain. This Woyome's letter is dated January 8th, 2010. Request for
Woyome.
Not exactly. For reimbursement for payment made on behalf of CAN 2008 local organizing committee. And it was specific, 77 $1,386 US dollars to do with some payments, financing plan for tournament, that is construction of stadium and all that thing. It was to do with environmental impact assessment. And Rex Danquest's letter is here, what he sent, and it's nothing to do with so-called financial engineering that has something to do with a Waterville contract. Nothing.
So why was it tendered in evidence?
I'm wondering.
Okay, I want to move on.
Hold on. And then there's another thing. You see, you go through the judgment and all those things, references to Bank Austria and all the rest. That too is absolute. I must choose my words well.
Rubbish.
I'm angry.
The deputy attorney general
Yes,
said rubbish.
it's rubbish. Thank you. Yeah. See, there's this letter dated June 21st, 2006, that was written to the Minister of Finance from Waterville. And they make the point that that's first line, Bank Austria, as you may be aware, withdrew from the projects. So the Bank Austria matter died long ago.
But it featured prominently here.
It's amazing.
But was this letter in evidence?
I
Was this
don't
letter in
think so.
evidence? It was not.
You see, it
So
was
the
worrying.
deputy attorney general must tell us more things.
This is, see, it's worrying.
It's not
every document. It's not every
But all
document.
this in evidence.
all this were available.
This is critical
to
to tell the judge that there was no financial transaction in the first instance. Now, if you don't give the judge this letter, why would you? Why would he err?
You must be asking us whether or not we had. I mean,
This letter, but I have it.
They have withdrawn.
Who has
And
it?
this was
do I know you how you
official
got
Oh, but you and I
They are
saw.
withdrawal from Waterville.
Okay.
So you don't talk about Bank Austria and whatever financial instruments they were bringing. You don't discuss it.
Look, if the deputy attorney general is only seeing these documents for the first time, then we have a serious
Are you
crisis.
aware of also the VAMED
The
withdrawal?
VAMED withdrawal.
No.
That is also
Oh, my
documented.
word.
I have copies here. And then you send Orlandi.
Orlandi to testify?
To testify. And he went there and said that Woyome was indeed entitled
to it.
percent. When earlier his own lawyer was saying
Was saying
no,
that he was-
and there are even letters between the two where they had fought before they reconciled. Look, it's mind-boggling. This is a banana republic.
And the judge said that gentleman's testimony also actually sought to support that Woyome did not defraud
We
anyone.
put him in the witness box and he testified against us.
No.
And then we are afraid of bringing
No,
other
he
people.
did not. He did not testify
let's hear
against
him.
us. If you look at the totality, no. I mean, this is the selectivity that I condemned at the beginning.
But the judge must have selectivity.
You know, yes, he must have selectivity, but he must, exercise that selectivity in a judicious manner. In a way that will bring about fairness in the outcome of the adjudicatory process. Okay, when the gentleman from Waterville, Orlandi, what is his name again?
Andre Orlandi.
Andre Orlandi gave his evidence. He made it very clear. In his evidence in chief, he made it very clear that Woyome was not entitled to the payment.
Really?
Wait,
No.
But in cross-examination,
In cross-examination,
yes.
in
He admits
cross-examination,
that he was
he says
entitled.
this. Now,
Yes. He said it was an independent claim. He didn't say that he was entitled to it.
Okay.
He said it was an independent claim.
I haven't seen
From
it.
that of Waterville.
I
No,
haven't
it
seen
is
the
here.
examination
Okay.
It is here.
Wait,
Okay.
I haven't seen the examination chief. You have seen it. But in cross-examination, this is what he says at page 6. Answer: yes, my lord. During the meeting, we were asked by the Attorney General to present our documentation in respect of financial engineering and other documents in respect of work done.
Yes.
At the end of the meeting, the Attorney General said that now I understand the position.
Yes.
And asked Waterville to present the claim for the work done and Mr. Woyome to present the claim for the financial engineering. So this witness now tells us that we all went before the Attorney General and put together our respective cases. In the past, we might not have believed that Mr. Woyome was entitled to everything. But after we had put forward our position on work, and he had put forward his position on financial engineering, the Attorney General said, oh, now I understand. Now bring your documents.
So does that mean the state was not defrauded? Does that mean the state was not defrauded?
No.
Does that mean that the state was not defrauded?
Or you must bring all of those people to book.
There was fraud.
Okay.
In fact, maybe you must bring all of those
I
people.
don't dispute that point you are making.
You use a word to describe the judgment. You said rubbish. Can we look in the mirror?
Okay.
There was conspiracy, fraud. They defrauded the state. It was a collaborative thing.
Okay, so in the Attorney General's estimation, which is the most important, jailing Woyome through a criminal process or retrieving the money?
Both.
Both.
both are
Where
important.
are we with retrieving the money?
Now, with the retrieval of the money, you know, we've you know, taken the necessary steps to apply to the Supreme Court. Basically, and I believe that again, you know, the Master of Civil Procedure will agree. If you look at the Constitution,
That was long ago.
the Constitution says that you can bring an action for declaration, and then there can be consequential orders by the Supreme Court and so on. However, CI 16, which is the Supreme Court rules, you know, does not make room for how those consequential orders are enforced. So at the beginning, and I had even a private conversation with Ace on this, the question was whether after the Supreme Court has made its orders, we now come under CI 47 before the High Court for enforcement, or we go back to the Supreme Court. Now, after a debate, I mean an internal debate, some of us took the view that, you know, we needed to go directly to the Supreme Court. Others took the view that we needed, you know, to go to the High Court.
Which you did.
Which we did. And then, of course, the lawyers, they started raising technical objections and so on and so forth. I won the first preliminary objection. We went on appeal, and I won again. That is in respect of the Waterville one. As far as the you know, the Woyome matter is concerned, okay, we are now before the Supreme Court for directions with respect to how we, retrieve the money because of the lacuna in CI 61. So we are making strenuous efforts, you know, to retrieve the money from Woyome, and we will retrieve the money from him. You know, we'll enter into execution and make sure that those money
has already he spent all the money.
Well,
his assets are still frozen.
There's a way to go about that.
No,
Yes.
okay, so I think there was a removal of the freeze order.
No,
Quite a while back. The bank account, there's a bank account freeze.
Yes.
No, but you see, this is 51.2
no, as at yesterday, I talked to the deputy executive, director of EOCO, and they are frozen.
That's his bank accounts.
Yes.
But do you have a list of
That's
his
the
assets?
ADB.
I thought I read that the court unfroze. But let's be
But it doesn't look as if
You
the
mean
Waterville one.
I think the initial one,
the High Court.
the initial one was a general freeze of his account.
His account.
And then
And that
later
was
they went and specifically froze where these monies were lodged.
So
So we assume that the 51 million will be found in his assets. So we'll go by the normal enforcement procedure, the 5 phase, attach them and sell them, and make 51.2 million cedis from him. No interest, painfully,
Right.
no interest. But we hope we can find 51.2 million, because as you and I know, the Supreme Court has now said that if you find out that he's a man of straw, that's it.
He can't go to jail for
He
that.
can't go to jail.
For the
End of
He
the
can go
story.
to
Okay.
jail for that.
Okay,
End of the
gentlemen.
story.
Okay, gentlemen, we are ending this
little
discussion.
bit
So, you know, what the public is interested. What timeline should we be looking at? I know it's a difficult thing to do, but what timeline should we be looking at when you intend to get the monies back?
Oh, in the next few months, or in the next few weeks, we should be, you know, entering into execution, and then I'm sure, you know, we already have, you know, a list of the assets and so on. So definitely, you know, in the next few months, we should have, you know, something to tell the people of Ghana with respect to how much we have been able to recover.
I see.
Yes.
Awesome. Very,
Well,
very.
I want him to
Pardon?
clarify.
It's unlikely that you recover all. Given
Well, we haven't done
There
that
is a
assessment
bank.
to know how much money he has and so on.
Okay.
As far as the bank accounts are concerned, I will be, you know, honest with the people of this country to say that we don't have 51 million sitting there. That one there, we have verified. We know the accounts. We know that we don't have 51 million sitting there.
Okay.
So
it's raised a very interesting point that it came without interest. Is that an
Well,
aspect
that's what-
that we can do anything about again?
that is what the highest court of the land has told us. And we are the principal legal advisors to government. We have no reason to disobey what the Supreme Court has
By
said.
now, he could have generated more than thrice.
At
that
25%, 4 years, 100%.
Well,
Or them clean.
Okay. Koku has a
It's-
They are
question.
taking
briefly.
our money,
Yeah.
multiply
It's
it.
looking as if the Waterville, the retriever is becoming almost a mission impossible.
not exactly. They've taken us to international arbitration.
Yes.
As I speak, I'm working with our lawyers in Washington, D.C. on that arbitration. We are filing, you know, our arguments. I think, yes, by the end of this month.
But
by the end of this month.
They don't have assets in Ghana. Nothing of that sort.
No, we haven't laid hands on any.
They don't. To be honest with you, I will not hold my breath.
No,
I will not hold my breath on what I'm supposed to
haven't laid hands.
What I do is looking like a national
They are registered offshore in the US.
Yes, that
You take the very final question on this one.
I think it's
It's a
interesting.
self-government. You get anything.
I think
What
it's
have you- they've
interesting
taken
listening
the
to the
money, they are
lawyers.
gone.
Yes.
But
Okay,
the
gentlemen.
bigger question is this. This case, 51 million, is not the only judgment debt situation
Yes.
we're facing, case
Yes.
we're facing.
Yes.
There are many. So from the public perspective, you want to know when these practices, which clearly shows that there is some institutional problems out there, some collaboration appears to be the case and so on. How, from your point of view as Attorney General,
When you say
how
collaboration, you mean collusion?
collusion
Yes.
or,
The
you know,
human-
civil, I mean, the
kill
way
the
relevant evidence doesn't go forward and all that and so on. So what would you tell the public in terms of what do you do within the institution, okay, to strengthen it and stop these weaknesses from happening? What is going to happen?
We work with the best human resource that we have. You know, within the constraints, financial and institutional constraints that, you know, we operate with. I believe that, you know, we are not a perfect organization. If we were perfect, we would not be criticized so roundly, you know, in the manner in which we have been criticized in this case. But we also know that there are other institutions or institutional stakeholders that are important in this matter. For instance, the judiciary. Okay, if we file a case before the judges, we lose control of that case in terms of, you know, I mean, the timelines, because those are governed by rules. We lose control because the judge can make orders when the other side, you know, has made an application and so on and so forth. So we need to collaborate with the judiciary in particular in making sure that all these monies that have been ordered to be retrieved for the state are retrieved. Okay, it's not entirely within our power to do so. We can only take the steps and hope that we get the cooperation of the judiciary in order to be able to...
I think at this point, what is most refreshing to the people of Ghana as they listen to and watch this show is that in the next couple of months, the monies will be taken from Woyome.
No, you're talking of Woyome money,
Yes.
not the what have you.
The
What have you,
Woyome
I'm
money.
telling you, it's almost
right.
impossible.
Okay.
We are
All right.
going to take us
Okay, so we take a break here.
We are making
break here, and when we return, we have very limited time to deal with the DCE, the District Assembly elections matter. We'll deal with that one very briefly, and we'll go to look where we can save a lot more money. The Auditor General's report. We'll be right back.